You may all recall that Sarah Boone had a very important motion hearing. We covered it extensively. We live streamed it. If you were able to join us for that live stream, we recapped everything that happened. Well, we were waiting on one specific order by the judge. And this was an order with respect to the defendant's notice of intent to rely on battered spouse syndrome or battered woman syndrome in this case. So just to quickly catch everybody up to speed about the background of before we got to this motion and order, the way it works in Florida is the following. You can't just show up to court on the day of trial and start arguing that your client is a battered spouse and that therefore can excuse her use of force in this case. What you have to do is you have to file a notice of intent. Notice of intent letting the prosecution know that you intend on relying on battered spouse syndrome. Now, we explained also that battered spouse syndrome itself is not a defense. It's a condition which can then lead you to the conclusion that this was an act in self-defense, but it in itself is not a self-defense. It's not a defense in itself. So just to make that very clear, again, the defense is self-defense. But to prove to the jury that she acted in self-defense, you have to prove, I mean, if you want, you can choose this avenue to show that she actually suffered as a victim of a battered spouse. And therefore, she developed this condition called battered spouse syndrome, which can explain why she would stay in the relationship. And that's all what the expert is going to testify in this case, Dr. Julie Harper, whose deposition is currently scheduled to occur. So what happened in this case was that the defense, this new defense attorney, James Owens, he filed a notice of intent to rely on battered spouse syndrome as part of his defense. Now, the rule in Florida is that you have to notify the prosecution, to notify the state at least 30 days before the trial. He filed two notice of intents. The first notice of intent definitely complied. It was 30 days before. It was more than 30 days before. The second, which was an amended notice of intent, that was actually filed closer to the trial. And there really wasn't much argument and discussion on the fact that that amended notice of intent was filed too close to trial, which I don't know why the state did not bring that point up. So that's your guess is as good as mine why they didn't argue that part. What the state did do is they filed a motion to strike the defendant's notice of intent. So even though the defendant filed a notice of intent and then an amended notice of intent, the state then asked the court to preclude the defense from bringing up battered spouse syndrome. They shouldn't be able to mention it in opening statement, in voir dire, and they shouldn't be able to argue that to the jury at all. They shouldn't be able to have an expert talk about it. Why? Not because it was less than 30 days before trial, but because they felt that the notice was deficient. It was a bare bones notice. It was just letting them know that there's a witness here. This expert witness, Dr. Julie Harper, is going to opine about Sarah Boone being a battered spouse. And that was the extent of it. Now, the actual rule of criminal procedure lays out that you have to get into some detail about what you want to argue. Whether, it's not exactly clear exactly what you have to do, but you definitely do have to state in particular as much as possible. And in fact, that was the last few words of the rule of criminal procedure that they were arguing about, is that the last few words says, insofar as possible. So as much as you're able to let the prosecution know what facts and evidence and witnesses you have to testify that Sarah Boone actually is a victim of a battered spouse, and therefore you're going to be arguing battered spouse syndrome, that much you do have to do. So that first notice that was filed timely was very bare bones. It was just essentially 3 different paragraphs, if you can call them that, really 3 sentences. One saying, we do intend on relying on battered spouse syndrome. Number 2, we have a witness here, Dr. Julie Harper, and this is her information. That was essentially what the notice was. Now, the amended notice added some additional witnesses, for example, police officers who investigated some domestic violence allegations between Sarah Boone and Jorge Torres, and some other witnesses that are going to testify, for example, Sarah's first husband, her ex-husband, Brian Boone. So there was definitely more of it was a bigger notice of intent, more information in the second amended notice of intent. Nevertheless, the state still filed a motion to strike those notice of intents. Okay, so those notices of intent, they want stricken. We had a hearing about it, and one of the more important parts of that hearing was that the judge was asking the defense attorney, are you going to be arguing self-defense or are you going to be arguing accident? And that's going to be a very important issue here because we know from some of the videos that we've already all seen that's very public that Sarah Boone was claiming that this was all an accident. She had no idea about what was happening and she didn't realize what was happening. She didn't realize he was going to die, et cetera, et cetera. This was all one big accident. Well, there's a clear case law, which is called State versus Wagner, which is in Florida, which says very clearly that if you argue accident, that this whole thing was an accident, then obviously you cannot then argue this was also self-defense. If it's an accident, that means it wasn't in self-defense. If it was in self-defense, then it wasn't an accident that you zipped him up there. You actually were protecting yourself. You acted purposely, intentionally to protect yourself. So you got to choose. You got to pick and choose which defense you're going to be using. And in that case, State versus Wagner, there is very clear evidence that the argument was accident, and therefore any sort of mention of battered spouse syndrome was precluded. And therefore, in this case, the argument in front of the judge was the state was saying she already claimed that this was an accident, and the defense was saying that, well, maybe it's self-defense. Actually, they did change their defense to being self-defense. Now, what is the defense, and what's the defense attorney going to do with those recordings and her statement saying that this is an accident? Okay, that's going to be something that they have to deal with. Nevertheless, now they want their argument to be self-defense. And this is essentially what went on during that hearing. So the judge took it under advisement. The judge says, I'm not ready to rule on this. I want to do a little bit more research. I heard the arguments. I read the briefing. Now I'm going to give me a few days to actually write an opinion. Well, he did come out with an opinion right now. So we're going to go through some of that opinion, and we're going to see what the conclusion was for this specific issue, whether Sarah Boone is able to argue self-defense, and part of the self-defense is going to be evidence that she was a battered spouse and that she suffered from battered spouse syndrome. All right. So this is what it says right here. I'm going to jump to, of course, the main parts of his opinion, because a lot of, he's just going through some of the dates here when everything was set, when the notices were filed and things like that. So let's get to the actual substance of his opinion. The amended notice, among other things, provides the same statement of particulars showing the nature of the defense as the notice and the names and addresses of 6 witnesses. So again, saying that the amended notice did show some more witnesses and some more information. On September 19th, 2024, the state filed the amended motion. The court finds that both the notice and the amended notice comply with Florida Rule Criminal Procedure 3.201B. Now, again, the basis of the state's motion to strike the notices was the fact that it did not comply. Their notices did not comply with Rule 3.201B. And for some reason, again, I don't know why, they didn't talk about the fact that the amended notice was less than 30 days before trial. And then there was some case law that were cited in the briefs, and we've gone through some of the case law in my previous videos. If you haven't seen that, you can definitely go check that out on this specific issue with Sarah Boone. Now, this is what it says. Medina versus State, State versus Hickson. State versus Hickson is the beginning of where battered spouse syndrome becomes a recognizable argument to be made in a murder case. Ladd versus State. All these cases were relied on by the state. All address exclusion or admissibility of expert testimony on battered spouse syndrome at trial. Those cases dealt with the actual trial. At trial, the exclusion or admissibility of expert testimony on battered spouse syndrome, that is what they dealt with. Not pre-trial exclusion of expert testimony on battered spouse syndrome. So the judge seems to be making a distinction between those cases in which the argument was, can we show this expert testimony, or can we have this expert testify during trial? Not a pre-trial motion to preclude the expert from testifying, which I don't know if it's such a great distinction, because again, the motion is that during trial, we should not be allowed, or Sarah Boone should not be allowed to show this expert testimony, or if that's through deposition, or to actually have the expert come in and testify. So whether this is pre-trial or during the trial, it's the same issue. During trial, are we allowed to, or is the defense allowed to actually have an expert testify? So that is, nevertheless, that is what the judge made a distinction. The state relies heavily on Wagner versus State. In Wagner, according to appellant's testimony, as she bent down to pick up the keys with her left hand, the gun that she was holding in her right hand accidentally discharged. So the case in Wagner versus State, again, was where there was a couple that was having some trouble getting into fights. And at one point, the woman left the house. She drove somewhere else, and then she came back. And she came back with a gun. And she was holding the gun. And her husband was outside by the porch. And she told her husband, I need my keys. Give me my keys. The husband went and threw her the keys. They weren't right next to each other. So he threw her the keys. She then bends down to reach the keys. This is according to, I guess, the defense's case. She reaches down to pick up the keys while he was walking back inside the house. And their theory is that somehow the gun went off and shot him in the back. And that she did not intentionally pull the trigger. And that she was not aiming at anything when the gun went off. The bullet discharged and struck the husband in the lower back. The trial court precluded appellant from presenting the battered spouse syndrome evidence at trial. So that was a case very clearly, the Wagner versus State case, where it's very clear that accident, if you're going to be arguing accident, you can't present testimony of battered spouse syndrome. And therefore the state was arguing that that's why Sarah Boone cannot present it in this case. At the hearing, no outright evidence of an accident was presented. See defendant's statements as outlined in paragraph 10 of the amended notice. And therefore, this is how the judge concludes in his order. Order and a judge as follows. Number one, the motion and amended motion are granted in part and denied in part. The motion and amended motion are granted in that defendant shall submit to an examination of an expert of the state's choosing. So one of the remedies, something that the state was looking for was that Sarah Boone should be examined by an expert of the state's choosing. So you may have your expert, Dr. Julie Harper, who's probably going to say that she suffered from battered spouse syndrome. We want to have our expert to examine Sarah Boone, talk to her, interview her, and give her opinion or his opinion, whoever our expert is, give our expert's opinion about whether that expert feels that she's actually suffering from battered spouse syndrome. So this was granted, which is appropriate, right? If the defense is going to have a chance to have their expert testify about Sarah Boone's condition, well, then the state should also have the opportunity to bring in their expert to examine Sarah Boone. And that's what the judge is allowing to happen. However, the examination shall not take place any later than September 26, 2024, which is tomorrow. The motion and amended motion are denied in that the notice and the amended notice shall not be stricken. So a big win for Sarah Boone. Then the notice and amended notice to rely on battered spouse syndrome is good enough. It's not stricken. The state's request to preclude defendant from mentioning battered spouse syndrome in her opening statement is denied. So you're allowed to mention this during your opening statement. Ladies and gentlemen, you are going to hear an expert, Dr. Julie Harper, who sat with Sarah Boone extensively and interviewed her and talked to her. And you're going to hear that she is going to opine that Sarah Boone was a battered spouse. She was the victim of consistent domestic violence. I'm just putting myself into the defense's shoes while they're going to be arguing this in her opening statement. That they're telling the jury, you're going to hear evidence of battered spouse syndrome. The state's request to prevent any mention of battered spouse syndrome until admissible evidence of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial is denied. So the state also argued that the defense should not be able to mention anything about battered spouse syndrome, even if the judge is going to say that this notice was good. Again, this was their argument. Even if you're going to say that the notice was good enough, but still the defense should not be able to mention the word battered spouse syndrome or argue that to the jury until they actually present good enough evidence that that Sarah Boone was a battered spouse. And up until that point, they should not be allowed to mention it at all. That was another part of the argument that the state made in their motion, and the judge denied that part. So a tremendous win for Sarah Boone. Now, again, Sarah Boone's going to have still a lot of trouble in this case, because how did she feel? How did exactly Jorge end up in that suitcase? Even if she is a battered spouse, at what point did she actually feel that she was in imminent danger, that somehow she was able to get him into that suitcase? And also all the statements that she made to the police that this was all one big accident. But it's not done yet. And the reason for that is that the defense, James Owens, the defense attorney for Sarah Boone, filed a motion just recently, just on September 24th at 3:30 p.m. So this is a very recent filing. And this is a motion to suppress all of Sarah Boone's statements. Now think about it. If you're able to suppress all of Sarah Boone's statements that she gave, which said where she was talking to the police that this was all one big accident, if you're able to suppress all of those statements, then your argument for a battered spouse is going to be a little bit easier. I'm not going to say that it's going to be that much more convincing, but it's going to be that much easier to make that argument, because then you don't have to deal with all of her statements saying that this was one big accident. So this is a two-step process here. First, they had to make sure that they get in this idea of this defense, I'm going to call it defense, but this part of the defense of battered spouse. That they did, and the judge granted that. Now they want to suppress all of her statements. And we're going to be doing another video on this specific motion to suppress all of Sarah Boone's statements. That's going to be a little bit later, so definitely tune back into Brother Counsel, where we're going to break down that motion, and we'll see if the state files a response, and then we'll see when the hearing is going to be set, because again, this trial is really quickly approaching, and all this stuff has to be taken care of before the trial. So we're going to be monitoring it all, bringing you live updates with analysis like this, breaking everything down, making it all simple, and that puts you in a better place to be able to watch and understand all these proceedings that are going on. Well, that is it for this video. Please, if you haven't yet, subscribe and like, and we will see you next time.